I'm driving by someone who's kind of interested. It's outside the church at 18. The park, that's right behind the church. Over the fence, a little tiny thing called Wellington Park.
I think I know where, yeah.
Yeah, she wanted to know if there's things that she can do at that park, at the church general, host an event to the community or something. They didn't know. I got them in touch with Christina.
Are we
the Parks and
ready?
Rec,
Mr. Fishball.
Because I know some of the options.
Yes,
Then I
we
got
are live.
talk to you today. And she wanted to call her.
All right, guys, we're going live.
I guess she's gonna talk about, oh, sorry.
Good afternoon, everyone. The hour being 5:30 on August 10th, 2022. I will now call the Public Works and Service Committee meeting to order. Mr. Pritzloff, would you call the roll, please?
Thank you, Madam Chair. Alder Jones,
Present.
Alder Pete,
Present.
Alder Lemke is no longer a member of the committee. Alder Pathrak is on vacation. Alder Ross and Alder Perez. Present.
Thank you. The first order of business is to approve the minutes from July 12th, 2020.
Second.
It's been motion and second to approve the minutes from July 12th, 2022. Any corrections, additions? If not, all those in favor, please say aye.
Aye.
Opposed? Motion passes. The first item on our agenda is 0545-22. Communications sponsored by Alder Pathrak on behalf of Rigid Frontier Eagles Club, requesting to close the 300 block of Hamilton Street from 12 p.m. to 6 p.m. on Sunday, August 28th, 2022, at the 17th Annual Car and Motorcycle Show. Staff recommendation that permission be granted for the 17th Annual Car Show and Motorcycle Show per the attached stipulations. Fiscal note, there will be nominal costs to various city departments on a regular basis to assist in implementing this event. Mr. Pritzloff.
Thank you, Madam Chair. Once again, this is the 17th Annual Eagles Car and Motorcycle Show. There's no issues from staff on this particular item. The stipulations are as such that are in your packet. We recommend it.
Any questions from committee members? If not, I will entertain a motion.
Second.
Motion and second to approve item 0545-22. Seems no questions or comments. All those in favor, please say aye.
Aye.
Opposed? The motion passes. Our next item is 0544-22. Communication sponsored by Alder Poe on behalf of Jamie Collins, Veterans Club, Inc., requesting to close Wisconsin Avenue between 8th Street and 9th Street on Sunday, September 24th, 2022, from 9 a.m. to 7 p.m. for the annual car show. Staff recommendation that permission be granted to the Veterans Club, Inc. for the annual car show per the attached stipulations. Fiscal note, there will be nominal cost to various city departments on a regular basis to assist in implementing this event. Mr. Pritzloff.
Thank you, Madam Chair. Once again, staff has reviewed this particular request and event. Everything appears to be in order. Looks like a fun time. All the stipulations are as shown in your packet, and we recommend approval on this one as well. I don't know if there's anybody here that would like to speak on this one.
No, I don't have anyone signed up. Any questions from committee members? Seeing none, may I have a motion?
Move to approve.
It's been motioned and second to approve item 0544-22. Seeing no questions, comments, all those in favor, please say aye.
Aye.
Any opposed? The motion passes. Our next item is 0553-22. Communication sponsored by Mayor Mason on behalf of the Downtown Racine Corporation, requesting permission to close Main Street from State Street to Seventh Street, Sixth Street from Lake Avenue to Grand Avenue, and Wisconsin Avenue from Fourth Street to Seventh Street for Party on the Pavement on September 17, 2022, from 12 p.m. to 7 p.m. Applicants also request a free parking day in downtown for this event. Staff recommendation that permission be granted to the Downtown Racine Corporation to close Main Street for Party on the Pavement and the following streets as listed for Party on the Pavement for the attached stipulations. Fiscal note, there will be nominal cost to the various city departments on a regular shift basis to assist in implementing this event. Mr. Fritzloff.
Thank you, Madam Chair. We reviewed this request. There are no changes to the way this is being done from the way it's been done over the last 15, 20 years, I'm guessing. We did take a look at the stipulations and there are no adjustments there. And the applicant needs to abide by those particular stipulations. So including that free parking for the particular areas that they had requested. Staff recommends approval.
Thank you. Questions from committee member? Alder Perez.
In section J of the communication staff recommendation, it talks about downtown, uptown, and West Racine from 12 to 7. And again, it doesn't include the ramps. Is that correct? Okay, the ramps have metered on them too.
Does not-
No, it doesn't include the ramps, however, whereas the ramps, this request has always been for the on-street parking, ABM by contract services, the ramps for collecting revenue at those locations, so. This is for the on-street, and I think historically in the past, they asked for free parking downtown. They've offered it to the other business districts as well, but I think it is intentional that the ramps are not included here because ABM manages those facilities. Also, if I can add to Executive Director Kelly Cruz texted me earlier that she couldn't attend the meeting, and I indicated that staff does support the request. So just so you know why she's not here.
Alder Perez, does that answer your question?
Yes, ma'am, thank you.
Any further questions from committee members? Alder Ross.
Do we know like how much revenue is generated in a day from meters? Is it just very little and it's more so for parking, keeping parking spaces open?
We might have calculated this a few years ago when the request to close the streets expanded the request for free parking.
Yeah.
I think Mike Meyerly ran some numbers on it. But we did not. It's become an annual request over the last several years. I couldn't tell you what that number is off the top of my head. I can see what we came up with a few years ago. I believe that question was asked. And we did have an answer for that, but I don't have one for you at this time.
That makes sense. It's not real
If
big.
it wasn't a lot.
Yeah, that makes sense.
Any further questions from committee members? Seeing none, I will entertain a motion.
Move to approve. Or second.
Motion and second to approve item 0553-22. Seeing no further questions, comments, all those in favor, please say aye.
Aye.
Opposed? The motion passes. Thank you. Our next item is 0509-22. Communications sponsored by the chair on behalf of Scott Terry, requesting to close Wisconsin Avenue between 7th Street and 8th Street in order to repaint the Black Humanity Now mural. Staff recommendations that the committee deny the request due to legal matters. Commissioner Remedy.
Madam Chair, committee members, I am gonna turn this over to Scott Letney to speak on this item from the city attorney's office point of view. And if you do have any questions regarding public works point of view, I can offer those afterwards.
Okay, we do have the, Mr. Terry is here. At this time, I believe we can allow him if he would like to speak to this item. Mr. Terry, would you like to speak to the item? You may come to the podium, sir. And if you state your name and your address for the record, please.
Afternoon, Mark, Scott Terry, 1422 Washington Avenue. I am speaking in regards to Dyke United Mural. I was a few things I want to point out is that the mural was really impactful for a variety of reasons. One of those reasons being bringing the community together. Also an economic driver for the community. We supported through the work, supported a lot of local businesses as an element of producing the mural. It was a destination point and continues to be a destination point for not only people in Racine, but also Racine County, but also Southeast Wisconsin as a whole. When we produced the mural, we had over 3,000 signatures, 3,000 petition that circulated with over 3,000 signatures. We also had over 100 volunteers from all walks of life, from all across generations, across racial lines, ethnic lines, and it was a very historic moment in time, in Racine. Racine has a history of being, an abolitionist city and being advocating for social justice issues. And this is one element that helped do that. I also want to point out that in the course of 2 years, there's not been a single incident with the mural, not been a single car accident, or single anything detrimental as a result of the mural. It has done actually the opposite of that. It's brought a lot of people together. It's also been a backdrop for teaching young people about a variety of topics, including American history, social justice in American history, but also how art and the arts has influenced social movements throughout history, American and world history. So we've done classes and workshops with students of Prairie, several of the public schools, and also adults, as well. So this is a fantastic, great community project, and I believe that it's something that should continue to move forward and continue to have a presence here in our community. Because again, as I mentioned, it's not just paint on the street; it's also a destination point for people who travel to Racine, travel to Wisconsin. When we did the mural, we had people from Minnesota, Michigan, Iowa, California, New York, as far away as Florida to come and participate, but also sign a petition and talk with me personally. And it wasn't just Scott Terry event. This is a community effort. I think it's something that should continue to move forward. And I do understand those concerns about legalities. I do want to point out that these same legalities existed 2 years ago when we got unanimous approval from the city council. And also there's a wide ranging support from the community of Racine County as a whole. So, this is nothing but positivity, nothing but support for the community as a whole. This is a rallying point to bring people together, not divisive. There's nothing divisive about this whatsoever, not in the least. And there was all the requirements that were put on us from the city was met, and there was no issues whatsoever. All the requirements that the city asked us to do, we did those willingly and without any issues, and we will do the same thing again moving forward. So if you have any questions, I'd be happy to answer any questions. And then that's it.
Thank you for the information.
Thank you.
And now Attorney Letney will explain our legal issues on this matter.
Might have come before.
Sure.
All right, this is going to take a few minutes. There's a fairly complicated interaction of state statute, federal regulation, home rule issues, under the state constitution, federal constitutional free speech issues that are all involved, and then there is potential liability facing the city based upon all of this. So let me say, I realized the common council approved this 2 years ago. I will say that, I would have preferred 2 years ago, the common council not approve it, because all the issues that exist now, existed then. But once the common council passed it, we did the best we could with a license agreement and requirements for Mr. Terry and everyone that was working on it. So, and just so you know, this was approved 2 years ago, and Mr. Terry executed a license agreement that has now expired. It was a 2-year agreement. It expired at the end of July. There was nothing in that contemplated, didn't prevent, but contemplated renewal. It just was a 2-year agreement. So some of this, I will tell you, is in consultation that I've had with the Wisconsin Department of Transportation General Counsel's office. So under state law, there's a statute, section 8619, that says that no sign, you think of a sign like a stop sign, the sign has a broader meaning than just a physical structure like a traffic control sign. No sign shall be placed within the limits of any street or highway except such as are necessary for the guidance or warning of traffic. The authorities charged with the maintenance of streets or highways shall cause the removal therefrom and the disposal of all other signs. So there is a basic statement in state statute that says nothing is within the right of way of a street or highway. And let me just say, all roads of any character in the state of Wisconsin are considered highways by definition. So when we talk about highways, it's any road, it's a little one-way neighborhood street or Highway 20 or I-94 are all considered highways. So basic prohibition against placing any kind of sign except for the guidance or warning of traffic within any streets. By state law, the state of Wisconsin has adopted the federal Manual for Uniform Traffic Control Devices. And there's another statute, 349.065, that says local authorities shall place and maintain traffic control devices upon highways under their jurisdiction based upon the adopted Uniform Traffic Control Devices Manual. In the Manual for Uniform Traffic Control Devices, it says that traffic control devices, announcements, advertisements, and other signs or messages within the highway right-of-way shall be placed only as authorized by a public authority for the purpose of regulating, warning, or guiding traffic. Now, the manual, MUTCD is 862 pages or something like that. It's a really dense document that contains a lot of material. And when you say one of the things that's within that is the use of colors on the highway. And certain colors are only to be used for certain purposes. For example, yellow is for warnings. White is for setting boundaries. Blue is for informational things, including such as disability parking and things like that. So there are a variety of requirements that colors be only used for certain purposes. The Federal Transportation Administration has issued opinions on decorative applications on highways. And it says, well, maybe it's okay in crosswalks, but we don't think it's okay to have any decorative applications on any highways in any other place. So one of the concerns, one of the opinions is, talks about intersection murals and street artwork have a potential to compromise motorist safety by interfering with, detracting from, or obscuring official traffic control devices. They can also encourage road users, especially bicycles and pedestrians, to directly participate in the design, loiter in the street, or give reason not to vacate the street in an expedient or predictable manner. For these reasons, exceptions to the manual's guidance for intersection murals and street art are not made. And it says past practice of intersection murals and street art have compromised the veracity of the crosswalk. The crosswalk is a traffic control device. And it does provide some guidance about crosswalk decoration. And generally it talks about things like bricks, sets, cobbles, or painting that resembles that sort of thing within the crosswalks as being the kind of thing that MUTCD considers acceptable or not objectionable. So there is this big body of law that says we're not supposed to paint anything in the streets except for traffic control direction. I have heard, and it is true, that there seemed to be an ability to do this in Milwaukee and Madison. I'll talk about that specifically, but just as an aside, let me say that every week the Wisconsin municipal attorneys from around the state have a call where we get on Zoom and talk about things, just whatever's going on in our municipalities. We bounce ideas off each other, and that call was at 1 o'clock today. And I asked the 20 or so other attorneys on the call, I said, does anybody have this? I know Milwaukee and Madison have these things. Anybody else? And nobody else in the state said we have one of these things. So let me start with Milwaukee. Milwaukee has, under their Department for Public Works, they have a permit process whereby people may seek to apply decorative artwork generally on sidewalks and in crosswalks. Let me say they're a little bit different, the two of them, but they're similar in these regards. First of all, the pavement has to be in a good enough condition for the paint that's used to actually work and be there. It has to be local streets only, so no state, federal, or county highways. For the crosswalks, it has to be at a legal crosswalk at controlled crossing, so an intersection. There, the posted speed limit must be 30 or less. Local or collector streets only. The artwork must be contained within the transverse crosswalk lines. No ads, no logos, no words, no political commentary, no religious affiliations, no letters, no script, no promotions. Also, no patterns that can be confused for traffic control devices. Got to use street grade paint that's slip resistant, non-reflective. The applicant has to be either a local business improvement district or a neighborhood improvement district, a nonprofit or other community-based entity. And there are some other requirements, both the crosswalk and the sidewalk requirement are very, very similar in Milwaukee. I am aware of at least a couple of places where there are, I'll just call it artworks placed on streets in the city of Milwaukee. It does not appear that whoever put that there got permission. They just painted the streets. Now, the city of Madison has taken an interesting approach. As I've said, there is a statute that specifically says you can't paint on the streets. except for traffic control direction. And it's section 8619. Now, this is where the state constitutional home rule issue comes in. So in Wisconsin, cities and villages are allowed to use what's called home rule, which is the cities can decide what's best for the cities. We can make decisions even if they don't exist in state statutes about things, and we can make decisions contrary to state statutes with some very, very broad exceptions. And one of those is if it's a statute of general application across the state. So there's a recent example of the municipal residency requirements when the statute changed and the state legislature specifically said, this applies across the state. So it said no home rule exceptions allowed in that instance. So just as an example. There's nothing in section 8619 that specifically says no home rule modifications here. I think were this ever to end up in courts, the court probably would say, look, this is a statute of general application across the state because it's talking about what you can do on the roads of the state. But in any event, what the city of Madison did is they said they enacted a charter ordinance raising this home rule issue that I talked about and said, almost verbatim what I'm about to tell you, we understand that under 8619, municipalities aren't allowed to let people paint on roadways. But we've decided that this is a home rule issue, and we in Madison are going to enact this ordinance saying, we don't care what the state statute says, we are going to allow this. But the statute, the ordinance is very specific. Let me just read something from the preamble. The purpose of this ordinance is to permit the painting of the roadway on certain local streets by granting a permit for neighborhood associations and others with a stake in the neighborhood to paint the pavement as herein provided. By permitting decorative application of paint, the city of Madison does not intend to create a forum for speech, nor to convert the surface of the highway right-of-way into a forum for speech. And then they say this, so they also don't intend these paintings to be an official traffic control device. Decorative designs hereunder shall be intended to enhance the appearance of the roadway and work in connection with the ordinary uses of the roadway, and shall not be designed to draw pedestrians or cyclists into portions of the roadway that are not intended for their use. Eligible applicants: a neighborhood association or neighborhood planning council recognized as such by the city, or a business association or other nonprofit community organization that would be eligible for a neighborhood grant administered by the planning division may apply for a permit to apply a decorative design, painted design on a roadway. There is an application process, and it's a very thorough application process. Madison also, by the way, has a much more thorough privileges and streets application process than the city of Racine does. And you've dealt with privileges and streets on this committee forever. So if somebody has a sign that hangs out over the right of way, for example, they have to get a privilege in the street under state statutes. There's a really specific process that Madison has. We don't have, ours works fine, but so they have to apply under that process. There's an application fee of $150 non-refundable. There's also a separate application fee for the street use permit. In order to even apply, and I've already said there can't be slogans, political messages, any of those kinds of things. A scale color drawing showing the detailed design and proposed location must be submitted. There has to be a petition with a signature from not less than 60% of the total number of residential dwelling units, businesses, and non-residential properties within a 200-foot radius from the proposed design location, indicating approval of the project and location. And in Madison, the city traffic engineer can expand that 200 feet to 600 feet. Each dwelling unit, business, and non-residential property is entitled to one signature. The alder of the district has to be noticed. Eligible locations. A painted intersection design. So this deals with intersection designs and mid-block locations under specific circumstances. A painted intersection design may be located at the intersection of two streets, both with a functional classification of local, we'll define local in a moment here, or a mid-block location on a street with functional classification of local. And local is only on streets with a speed limit of not more than 25 miles per hour and not located within 200 feet of an intersection with a street with a higher functional classification. So I just will note by ordinance, everything south of 7th Street on Wisconsin Avenue is 30 miles an hour down to 16th Street. So where we in Madison, this wouldn't apply. And then of course it's within 200 feet of Washington Avenue.
Yeah, Wisconsin Avenue is functionally classified as a collector street,
Okay, so it's not a local street.
not a local street, correct?
The proposed, so and again, we're talking about the Madison ordinance. The proposed painting shall include only decorative designs and patterns, shall contain no text, numerals, symbols, overt messages, or any images designed to convey a message of any kind, including commercial messages. There's some more specific requirements. The design shall not create a three-dimensional or multi-dimensional effect or other optical illusion. The design shall not include any element that mimics or imitates an official traffic control device. Shall not include any element that interferes with or hinders the visibility of an official traffic control device or marking already in place, such as stop lines, marked crosswalks, edge lines, lane markers, bike lane markers, etc. And it also has to pass through the city traffic engineer. No design shall include any feature or element that, in the opinion of the city traffic engineer, will create a safety hazard for vehicles or pedestrians, and then nothing about the design may violate any applicable city, state, or federal law. The traffic engineer has to review the design to make sure it actually meets all the circumstances. And then there's some specifics about paint materials, and then approval process and appeal process. There is also a requirement that that the requestor indemnify the city and provide insurance. And while we did ask that insurance certificate be provided during the painting the last time, in Madison, the insurance in favor of the city, the indemnification in favor of the city, has to exist for as long as the mural or artwork exists on it. So it's a general commercial liability insurance policy. So for example, we deal with trip and fall cases in the city on every once in a while, somebody sues the city, they tripped on a crack in the sidewalk or something. And there was a case a few years ago where somebody said the reason they tripped, besides the sidewalk issue, is they were looking at Christmas lights at the time and didn't notice that there was a defect in the sidewalk. So they were distracted by other things that they said. The city let people have Christmas lights up. I tripped and fell, city, it's your fault. I can imagine, without stretching that imagination too much, that somebody might say, I was crossing from the law enforcement center to the courthouse on Wisconsin Avenue. I was looking at the mural, I tripped, I didn't see, or there was a car driving, I didn't pay attention, and so want to sue the city. So the Madison procedure would require an insurance policy in favor of the city for the entire time the mural exists. This also doesn't contemplate renewals. If Somebody wants to renew it, it's a brand new design, and then there's some other technical requirements here. Let me just address the issue where Madison says, by permitting decorative application of paint, the city of Madison does not intend to create a forum for speech, nor to convert the surface of the highway right of way into a forum for speech. We could spend hours talking about First Amendment free speech issues as it relates to government interaction, but let me say that very broadly, in places that are considered to be traditional public forums, such as streets, sidewalks, parks, plazas, Monument Square is a good example, where a government would say, we approve some sort of speech to take place, it then becomes very difficult in the future to deny other speech. So while everybody may agree that this particular project is the kind of message that the common council wants to support and people can agree with, it's not hard to imagine somebody asking to paint something on the streets that fewer people would agree with, or maybe everybody would disagree with. And the problem becomes, if you say yes to this, you truly cannot say no to another without incurring the possibility of being sued. Free speech litigation it's big business right now, and it comes in all kinds of ways. One of the ways that got to the Supreme Court recently was with regard to a municipality controlling how and when commercial signs, billboards can be up there, based on freedom of speech issues. Speech related to religion, the way the Supreme Court is going nowadays, if you let somebody say anything that's non-religious, you can't even hint at saying no to something that is religious, because the courts have said you can't treat religion any bit differently than anything else. And there is a very recent case, I think it was decided in May, maybe June, City of Boston case. The City of Boston has a public plaza. It's similar to the one that we have at City Hall. It's a little bit different, but they have some flagpoles up there. And historically, for years and years and years, anybody that asked could fly their organization's flag on that flagpole. It's Serbian Day, or we're celebrating Boston Red Sox, or whatever it is. People could say, I want to fly the flag, and the city would universally grant approval for people to fly the flag. Then somebody asked to fly a flag that had a cross on it, and whoever made the decision said, no, I'm concerned that if we approved this, that we would then be seen as supporting one religion over another. I mean, it was a rational analysis at the time, but they only looked at it from that way. The Supreme Court said this is a free speech case. You allowed all these other organizations to use that flagpole to proclaim whatever speech they wanted to. You can't now say no to this one. And it literally went all the way to the Supreme Court, and they said that. And frankly, I have concerns from a liability perspective that if the Common Council allows any painting on the street that has some sort of message, whether it's religion or political or commercial or Go Brewers or anything like that, that if the council ever said no to something, that the city would be sued. That's purely speculative. I don't know if the council would ever say no, and I don't know whether the city would get sued, but it concerns me. We did, after this project was approved by the council, we had another organization ask to paint a slogan on the street. Now, they wanted to do it on the roundabout.
Yeah.
And the roundabout obviously is Highway 20. It's certainly not a local street. It's a completely different character. It's a state highway. It's not a city street. I think somebody from John's office talked to them, and they withdrew it, or it kind of kind of faded away.
Yeah.
But it was a different character of message than this message is. And I frankly would be concerned if the council would say yes to this and then someday soon, or someday 20 years from now, say no to somebody else. So it's my recommendation from a purely legal perspective, that has nothing to do with the character of this message or the artwork or anything else around it. From a purely legal perspective, I would just rather the council just say no to this, because principally, we're not supposed to allow anybody to paint anything on the street that's not traffic direction. That's the statutory rules again for uniform traffic control devices. Now, if the council has a desire to consider allowing decorative artwork on pavement, I would ask you to consider establishing an ordinance or a policy with guidelines specific to what can and can't be done before considering this or any other. But based upon what we have right now, which is nothing, setting policies, I'm really concerned about the ad hoc consideration of these kinds of things. So, as I said, from my perspective, from a legal perspective, I recommend that you deny this. If you want to do something after that, that's obviously your call. That's my recommendation.
Thank you. Mr. Attorney Landy. Commissioner Rooney, did you have anything else before I ask committee members if they have questions?
Sure, purely from a public works standpoint, as a commissioner of public works, I don't support, any type of painting in the public right of way that isn't, one, approved by the Federal Highway Administration's Manual on Uniform Traffic Control Devices, and is done under the supervision of DPW. That means one of two things. We either contract with a company that does an improvement project, and part of that is painting. Generally, those are they're following plans and specs that we prepare, or they're prepared perhaps for the DOT, or it's routine maintenance painting that we do with DPW every year this time of year. We have to go out there and remark those pavement markings out there so we can give motorists guidance on what to do. It is very specific about paint in the MUTCD. There's a whole chapter on pavement markings. There's chapters on signage. There's chapters on traffic signals. There's chapters on school zones. You name it, anything that has to do with the movement of pedestrian, vehicular, or bicycle traffic is identified in the MUTCD, and it's done there for good cause, good reason. That MUTCD was developed by the Federal Highway Administration. So if you and your family or your friend want to drive, say, from here to Florida, you have a reasonable expectation to encounter uniform traffic control in every state that you drive through on the way while you're making that trip, so that you don't see signs, pavement markings, signal operations, or what have you, that would be contrary from state to state. You want to be able to travel there with the understanding of what the general rule of law is when you're traveling on public rights of way. So I think it's very important that the MUTCD is, the state, as Scott mentioned, adopts the MUTCD. The state can modify the MUTCD, but to bring it to a higher standard, for example. So they do have that ability. For example, in some states, they require maybe more traffic signal standards or heads to face motorists, maybe for redundancy purposes, because they get knocked down more often in northern climates. Whereas in southern states, they don't require as many. So maybe you can get away with 2 signal faces on the far left and far right facing traffic, or in another state, they may say, we'd like 3, you're right. These are the things that they change just to increase, lower the standard. Sometimes states increase it just because of their own issues revolving their region. So that is my stance as Commissioner of Public Works. In addition to that, we just went through a project that the committee approved that costs over 6 figures to modify Wisconsin Avenue this year. Wisconsin Avenue was changed from a one-way street to a two-way street. That was done in accordance with the tool plan that was adopted by common council for the downtown public realm and parking study. And part of that plan was the common council was desirous of seeing a lot of these one-way pairs flip to two-way traffic. So we get greater mobility downtown, help the motorists get around a little bit easier, find parking easier, better circulation. Well, in doing so, we started with Wisconsin Avenue conversion this spring. This is not an easy thing to do. And we were very intentional about the way we did that project, the way we staged it, the way we put the plans together, the way we instructed the contractor to do it. That one way existed for, I believe, 57 years. It was in place before I was born. So there's a lot, and I'm getting older, and we are all creatures of habit, and we tend to always do the same thing. So we had a lot of angst and hand wringing on how to engineer that to make sure when we started doing this work and reintroducing different types of pavement markings, changing signage, changing traffic signals, we want to ensure we are doing that with all the users of that roadway safety in mind. That was paramount. So the way we did that, we can boil it down to it's as simple as the yellow line in the middle of that road indicates bi-directional traffic to any motorist. Where white is you're going in the same direction of travel. Now, whether it's solid edge line from the edge of the pavement, or it's indicating you cannot change lanes, it's not permitted. You have to stay in your lane. But yellow is indication of bidirectional traffic. Everything we did up there was very intentional, and we marked it per the MUTCD. We didn't introduce any other things. We realized the existing mural was out there, but we painted over it. Obviously, it's worn, but we wanted to make sure when that was open that we didn't have issues out there with traffic. Knock on wood, I think it's been very successful, the project. People are getting used to it. What worries me about this particular request is that we just spent all that money converting that. And for someone who maybe is now getting used to the new traffic pattern, there's going to be other pavement markings out there that may confuse them. So I think that's something that I have a little angst with as a commissioner of public works. So in general, like I said, it has nothing to do with the message. It has nothing to do with, the good intentions of what people want to do when they want to try to, express whatever their interests are. I just do not believe it belongs in public rights of way. Can be done on private property, billboards, other areas, maybe of public space, but not in areas that are regulated by the MUTCD that the Public Works Department has to follow to the letter. So that's my opinion on the public right of ways place pavement markings out there. So if you have any questions for me, you can certainly ask. I know you might have some questions for Attorney Letney as well.
Thank you, Commissioner Murray. Any questions from committee members? Ross.
Hey, I talked to a few people. I talked to directors of public works and traffic engineers from Madison, Milwaukee, Wausau, Stevens Point, as well as the attorneys from them. I will be going up to the state DOT this weekend, should this pass through here, so I'll have more information for the common council. But I did learn a perspective on it, and it makes sense. The MUTC, the perception, or the perspective from the Department of Public Works and the traffic engineer, it makes sense. That only exists for the guidance and standardization of road traffic and traffic control devices. There's no wording in that MUTC that is meant to emphasize art and culture. It's not built for that. It's not built to go through that perspective. And from a legal standpoint, it makes sense because these types of things add legal liability, because having the most basic and standard traffic control devices is the safest, both in traffic engineering and in legal terms. But But I think the decision-making process that we have to make from an alderman's perspective have to be a bit more broad. And I would hate to use my position as an alderman to squash something that has cultural relevance. And going back and changing a decision and changing something has a lot more weight than making a decision in the first place. So maybe you are right, that having more oversight and having a better plan in the first place would have stopped us from having these issues. But I see more of an issue if we were to strip this away than if we were to leave it and have the possibility of an outcome. I would rather look to try to grandfather something like this in and then immediately come back with a program similar to probably in between Milwaukee and Madison. We don't have the staff and capability to do something as intense or probably the type of engagement at our level to functionally use something like that. But something along the lines of Milwaukee, which I talked about with program directors for both the programs in Madison and Milwaukee. And it kind of reminds me a little bit of what happened in Madison. During a protest in Madison, people painted defund police right outside City Hall. This was not approved, this was not sanctioned, this was not technically allowed, it was illegal. But the mayor and the police chief decided not to remove it and decided not to charge anybody. And kind of along the same perspective as how I feel now. It would have caused more of a problem at that point, should they have made the action to remove it, reject it, to go after those people. It would have had more of an issues culturally with local engagement. It's more of a problem that was solving. I guess if I wanted to find a more toned down comparison, I would think about it as adding a roundabout to a new intersection. We can go back after an intersection has been created and say, wow, it would have been a great idea to put a roundabout, a great idea to put a median here. But we just built it, so we're not going to rebuild it. That's a great idea. Tell me again in 20 years, kind of thing. So I would rather see this grandfathered in and to work to build something that doesn't put us in issues of First Amendment rights come forth for all remaining future projects. So I think we've already had artistic road designs, maybe not as permanent, but I remember one outside Walden that they got out and colored in the crosswalk. I know there's been several other, I'm starting to forget them. But I don't see that part as an issue. I don't see issues with the MUTCD as the main issue. I think the First Amendment right is probably the biggest issue that we face because we haven't had an accident in that area. Madison hasn't had any issues with any of their painted roads, legal or not. Milwaukee hasn't had any specific issues. Wausau with theirs and Stevens Point specifically, their DPW told me that he was not in favor when they had the painted crosswalks for the same reasons you stated for the legal issues. But he recognized that as his position. But he told me that they had no issues with it. Another area that they go against MUTCD is with their street signs on campus. They use a purple and white contrasting street sign, even though it's still serviced by the same municipality in Stevens Point. But he said that despite that going against that MUTCD, he thought it was more of a benefit to the area than it was of a detriment. It allowed people to know when they were on campus and when they were not on campus. So he was fine with it. But we're the ones that have to have flexibility to try to make that work. It wouldn't make sense to come as a recommendation from DPW or from the attorney's office. So I understand why this is recommended for denial.
Yes.
Oh, sorry.
Oh.
Well, I just want to comment too, about the MUTCD. I've been reading it for over 2 decades. And I would have to say, I think I know it better than anybody in this room. So when you talk about the MUTCD and you understand what's in it, understand what you're responsible for, like myself and the department that I manage, so when you say, oh, they use a different color sign or this or that, read that document very carefully. There are shells in the MUTCD. You shall do this, you don't waver. There are shoulds and there are mays. So they give you flexibility on different aspects in the WTCD. So don't take that as a blanket statement that, one public works department allowed to use a different color wayfinding sign perhaps than another to say, well, you can do whatever you want. I just want to caution you on that. There's very, very, very restrictive things that you cannot vary the WTCD. Those are all listed as shells. And if you want to read all 600 or 800 pages are in there, you'll find those things in there. It's a good cure for insomnia. Then the other thing I just want to comment when you talk about what the city of Milwaukee, does up there and say, well, maybe could that. even what the city of Milwaukee is doing up there, and I just looked at this today, it isn't allowing what is being proposed or what has been done there. This is limited to crosswalks, and, you know, on its face, I'm not gonna get into this or want to try to come up with a new policy. Remember, I think that policies are there for norms, you know, and I think people should govern to be, you know, not to the exception to the norms. But I think there must be a real need up there where people want to decorate or embellish crosswalks. And those actually can be good things, but they are very much requiring that the edge lines be painted and maintained on a crosswalk that define it. They want the stop bar to make sure that that is placed there. And what they're doing in the middle is simply painting something in there. And that's where the MUTCD, again, if you follow it, the MUTCD gets updated often. I don't know what revision, I don't know what revision we're on, but there's been more than I can count on one hand over the years. And they are always looking to have better contrast in crosswalks. That's why they have allowed the use of colored pavements. We use them now. We put colored crosswalks, you know, we use colored pavement. And I think that's what they're talking about there, because that contrast for an approved sidewalk location, why they reference it needs to be at an intersection, because that is where motorists expect someone to cross. And you know what, they allow different style crosswalks. It used to just be two lines that went across the street. Now they're using, you know, the block pattern, the zebra style. And they're all in the MUTCD, and even the approved use of different colors in the MUTCD. I think when they're talking about this type of painting, they're loosely saying, you know what, you're using red colored concrete, you know, that's injected in the mix, and it creates contrast, and that's not a bad thing. So I kind of want to put some context into what I think Milwaukee's doing here. And like I said, I don't think that's a bad thing, just for my opinion. Helps the motorists and people on motorcycles, vehicles identify those crosswalks better. And I think it's helpful for pedestrians. So it's not a bad thing. That's my opinion on that.
That's what I think we have to look like going forward.
Chris,
Thank you, Madam Chairman. I do remember the other political group, it was Hot Government. They wanted to put honest, open, transparent on the circle in front of City Hall. And also, they did that with the intent of making a political statement, because they believe that all lives matter, all humanity lives matter, whatever it was over there, also made a political statement, which was relevant at the time. It's relevant today too. However, I also know that the explanation that Attorney Letney gave today was much more explicit than what I remember from the last time. And a lot more information that I personally was not aware of. And also Alder Rouse said that, you know, in his comment, what I understood was that we just can't say, oh no, we don't want to follow that law and ignore it. If the law is the law, the law is the law. So I'm torn myself. I think, as Mr. Terry said, it's served a great purpose in our community, a binding community purpose. And it's brought people from other areas into the community as well. But I'm also concerned that if we continue to do this kind of thing, that precedent will be cited for other people's political statements. And this is in fact, you know, whether you want to believe it or not, it's a political statement. So I'm torn because I know that I voted for it last time. But now that I have a better explanation from Mr. Letney, I'm concerned that we are ignoring the law and that we can't continue to do that. We've done it several times now on different things, and it's caused us very little problem, but legally we're wrong. That's all I have to say. That's fine.
Alder Pete.
Thank you, Madam Chair. I kind of want to echo what the four people said, but I will try to keep it simple. After hearing what the attorney and commissioner said, as well as the other two alders, I would like to be the defense attorney that represent the person that would be suing the city if something happened, because we're not following the laws. So, you know, it's like, well, you allowed it, you didn't follow the law. So that doesn't look good. It's very unfortunate that we're in this position. But again, as the two aldermen just also pointed out, as both attorneys with me, if one person is doing it, then my freedom of speech, like the example he gave. So you're opening up Pandora's box, if you look at it that way, and which is very unfortunate.
Thank you, Alderman. Any further questions from committee members? And I kind of echo what everyone has said. I think when we voted it in 2 years ago, we just weren't aware that those laws were out there, that we
Yeah.
shouldn't have voted them in. And now that we are aware of it, we are bound, or we should follow the law.
We're troubled by it, I think.
So, anyways, if there are no further questions, comments, I will ask for a motion.
No question, Madam Chairman.
Alderman
So-
Hess.
Thank you. A receive and file as opposed to a direct denial. What is the implication of that? Maybe Mr. Litton can explain that for us.
A receive and file generally means you've received some information and thank you for that information. There's no action to be taken. A denial is clearer. It's absolutely saying no. In neither case, whether it's a denial or a receive and file, will go to the common council, only things that are approved. You know, there may be a semantic difference between the two. I will say that years ago, when I first started working here, the committees would almost universally receive and file when they meant deny. And then it got confusing at some point when you go back and look at Legistar and couldn't tell whether it was a denial or a thank you for this information kind of motion. So, you know, over sort of evolved into, if you mean deny, say deny. If you mean receive and file, say receive and file. But I will say effectively, a receive and file would be a denial in this case, because it would not go to the common council, and that would be the end of the item. But denials, denial.
Alder Ross.
Just out of curiosity, the four of us here, what happens with the split vote?
Who dies?
Well, it depends on what the motion. I mean, you know, if somebody moves to adjourn at this moment, and it's 2-2, it doesn't have majority, so it doesn't pass. So if the motion is to approve and there's a tie, then that doesn't pass. If the motion to deny is a tie, it doesn't pass. So,
What happens if we keep hitting that impasse?
well,
Not that it might happen, I'm just curious.
I think it had moved it forward on Robinson.
there,
Have things moved?
when that's happened in recent memory, the decision was made to take it to the council and have the council vote on it, where there was a tie, so there really wasn't a recommendation from the committee. So it hasn't happened much in my recollection.
And could that happen, let's say, if it's a move to deny or approve, either way?
I mean, if the committee cannot have a majority, then, you know, the committee could decide, let's just have the common council deal with this.
Thank you. Does that answer your question, Alder?
Thank you.
Well, we are still back to a motion.
Move to approve.
Moved and- No. No, right.
Well, the recommendation is to deny. So he moved.
So I wasn't sure. if-
No, that's what we
That's
said.
why I said to stop, because I wasn't sure what he meant.
Yeah,
Yeah.
you got to clarify what you're
He
moving.
said move
Yeah.
to approve.
Move to deny recommendation, move to approve the item.
There's some recommendations to approve that.
Okay.
They're doing a deny.
So
So
clarify. I think move to reject.
I think you should ignore the recommendation when it comes to what you want your motion to be. So if your desire is to move to approve the request
Yes,
submitted by Mr. Terry, then it will be moved to approve the request submitted by Mr. Terry.
that makes sense.
Okay, and then it's really clear. So, because you can make any motion you want, you don't have to say, move to, approve the staff recommendation. It doesn't have to be done. So.
Move to approve item 0509-22.
Again, to be clear, you mean move to the request, move to approve the request. of
Yes,
Secretary.
request.
Is there a second? Is there a second? If there is no second, then the motion dies for the lack of a second. Now,
So you can ask if there's any further questions. Okay.
thank you.
Sorry.
Are there any further questions?
And move to deny the application.
Second.
It is a motion and second to deny the application of Mr. Terry for repainting the Black Humanity non-mural on Wisconsin Avenue. Any further questions, comments? If not, all those in favor, please say aye.
Aye.
Opposed?
Nay.
Motion passes. Thank you, everyone. Thank you, Attorney Letney, for your information. Most helpful. Our next item is 0541-22. Communication sponsored by the chair on behalf of the Department of Public Works, submitting bid results for contract 2022082, parking lot structural repairs. Since no bids were received on this contract, that the project be rebid and the item be received and filed. Mr. Person.
Thank you, Madam Chair. On Wednesday, August 3rd, Department of Public Works received bids for contract 2022-082, which is parking lot structural repairs. It's a project to handle all of our parking lot structural repairs to some of our most, more of our areas that needed attention. We didn't get any bids. And so we're requesting that you receive and file this item and that we do bid it.
I have a motion. Move to receive and file.
I have a question though.
Alvarez,
What level of degradation is there on the ramps? Is it a safety concern?
Well, yes and no. I mean, it's not an immediate safety concern, but there was areas in the structures that we've identified that needed to be fixed. In particular, we have, 441 Lake is one of them, but we're not looking at catastrophic failure type issues. It's more of a routine maintenance type of situation.
If I may. Think of it this way, it's more of routine maintenance, if you will. We do this type of work, we try to schedule it every other year as not let the ramps deteriorate. So we don't have expertise, PPW, in doing structural repairs with our staff. But we don't ask you about street maintenance, like real crack fill or joint seal or things like that. So this is the kind of work we contract out to keep those ramps in a good state of repair, just like maintenance we would do with staff for the roads. So think of it that way. None of this is because we don't do this right now. We have to shut a ramp down or a section of a ramp down. I believe if that situation occurred, we would probably go into an emergency procedure for curb services, which I think is allowed to happen, in that type of event. So I hope that answers your question.
Yes, sir, because I remember we closed down a ramp because it needed to be redone last couple years ago.
Yeah, so we're gonna try to rebid it again, try to contact, they're all busy or we don't know what that is. We're gonna reach out to them and see if we can't get some bidders next time around. push comes to shove, we'll bid it out later in the year, beginning of next year, not to do with
Yeah.
2023, so we'll see.
Does that answer your question?
Yes, ma'am. Thank you very much.
Any further questions from committee members? If not,
Second.
motion and second to receive and file item 0541-22. All those in favor, please say aye. Any opposed? Motion passes. The next item is 0542-22. Communication sponsored by the chair on behalf of Department of Public Works, submitting bid results for contract 2022083, park service building parking lot paving. Staff recommendation that the contract be awarded to A.W. Oates and Son, Inc. in the amount of $159,067, plus an alternate bid of $39,030 for a total bid of $198,097. They being the lowest responsive bidder. Fiscal note funding is available in order object 45045-57110, parks land improvement. Mr. Fritzloff.
Thank you, Madam Chair. Defer to Director Novak. This particular item.
Thank you.
Thank you. So this parking lot is, sits outside of our park service location that our park division works out of on the corner of, I think it's Lockwood and 13th Street. That parking lot, we're looking to get paid, and the dollar amount is in the budget for this, and we're looking for approval. And I can answer any questions you might have.
Alder Perez.
Thank you. Is this the same lot that we fenced in last year?
Nope, that was,
That was also on
that was a
Lockwood.
storage area. This is actually for our staff, which right now I believe it's gravel.
Okay.
It's be a better situation.
Why on the description it said it's not a Racine Works program contract? What, how does that work?
It's my understanding, but I think Ron can probably answer better. If it's under the dollar amount of $200,000, it doesn't.
That's correct. By ordinance.
Okay, and what's the alternate?
So when we first, we first went in just as an area that we felt that we could accommodate for our staff. And then once we got into it a little bit more, there was an area that we could actually pave. And if for whatever reason our staff got bigger, we would already have it completed. So that was the alternate part, just to make the parking lot bigger than what the base bid is. And it fit underneath our dollar amount, so we'd like to do it.
In the simplest terms, the base bid is what you need to get done, and the alternate bid is the nice to have.
Oh, yeah, okay, sounds good. Thank you.
Any further questions from committee members? May I have a motion?
Move to approve.
Motion and second to approve item 0542-22. Seeing no further questions, all those in favor, please say aye.
Aye.
Any opposed? The motion passes. Our next item, 0543-22. Communication sponsored by the chair on behalf of the Department of Public Works, submitting bid results for contract 2022084, parts of asphaltic paving. Staff recommendations that the contract be awarded to BK Contractors, Inc. in the amount of $508,230, they being the lowest responsive bidder. Funding is available in order object 45050-57110, parks land improvements. Mr. Novak.
So yes, I can speak to this. So this contract is actually for 4 different projects. We felt that by putting all 4 together, we get a better price. The locations are Lockwood Park. There's a pathway that goes off of the road that comes into the park to the shelter that is deteriorating and needs to be a little larger and a little thicker so that it can sustain vehicles and other things. Hamilton Park pathways, if you don't know, we've been working with the aldermen in that district right here and the neighbors, and part of finishing that park off is removing old existing pathways and putting new ones in for the neighbors and whoever would like to use the park to have access to the areas that they want to get to. Cemetery roads is exactly what it is, it's cemetery roads. We do this every year. And then the last one is Island Park. The tennis courts that are sitting out there now will become 2 tennis courts and 4 pickleball courts. And this came in a little more, it came in higher than what we anticipated because we changed the scope. We added a little more asphalt area on the, what side of it? The way you would enter into the caged in tennis courts and pickleball courts. We added a little bit of extra pathways so that you now can go around the entire park on a pathway. And this allowed us to do that. So it was a little more expensive. We did call finance and got approval for the dollar amount that it went over. I can't remember exactly what it was, but I want to say it was about $60,000 more than what we anticipated. But the money is in that CIP dollar account, so we'd like to see that be approved, so those projects can be done. And I can answer any questions that you might have.
Alder Perez.
You said that you put a path around the park. Is that like a running path or a?
Oh, no, there's already an existing pathway, that's the Root River pathway. And so along the pathway, there's a path already. And then on the
But
other
it's a
side.
walking
there's-
path?
Yes.
Oh, okay.
Yep. Yep, and so now you'll be able to go with this pathway coming off of the parking lot, going past the tennis courts. You can now pick up that Root River pathway. So you can make a whole entire circle around the park, which has been a request from some participants in there. And now we can accommodate with this project.
Is there a standard closing time of the park?
All parks are closed at 10 o'clock at night.
What kind of lighting are you providing along the pathway?
I believe there's already existing light that's there, but the new part, we don't light any of the only tennis court / pickleball court that's lit at this point in the city of Racine is at Lockwell Park. So there will be not, we will not be putting in lights for these courts at this time.
And not even along the pathway is what I'm asking, the pathway.
Not along the pathway, there's enough light from the parking lot to cover the existing pathway that has lights, that it won't be.
Okay, thank you.
Any additional questions from committee members? Alder Ross.
I'm just, I like the idea of combining them, going through line by line, comparing from this last contract, and it seems like we saved a lot of money overall by doing
That's the idea.
Yeah.
Sometimes it works, sometimes it doesn't.
Alder Ross, did you have any additional questions? No, great, okay. Any further questions, Alder Perez?
No, thank you.
If not, motion is in order.
Move to approve.
Motion is second to approve item 0543-22. So no further questions or comments. All those in favor, please say aye. Opposed? Motion passes. The next item is 0558-22. Communication sponsored by the chair on behalf of Angela Zimmerman, Racine Public Library submitting change order number 1 to contract 2022036 Racine Public Library interior renovation, garage construction and engineering Inc. contractor. Staff recommendation to approve the change order in the amount of $4,497.84. Mr. Pritchard.
Thank you, Madam Chair. Director Zimmerman couldn't be here, so I'll be speaking on her behalf. This is change order number 1, covers roughly 9 items for $4,900.
Director Zimmerman had asked me to relay to you that she has approved all these. And in fact, that the board gives her approval up to $25,000 on any change order. So that's point number one. The change order covers, minor changes in, windows, door frames, doors, electrical, sprinkler head location moves. And the biggest dollar item there was that negative that we removed that $10,500 there for the flooring. Excuse me, not the flooring, the graphic film on the glass. So that brought it down by $4,500 roughly. So, excuse me, $4,500. So request approval.
Alderman Perez.
So what changes, I mean, how does the change order come about? I mean, they look at what's being and go, oh no, we want a birch door instead of a oak door. What, I mean, how do they determine the need for a change order?
I guess that would be up to Ms. Zimmerman. I can tell you how I would determine the need for it is, in the case of the sprinkler heads, maybe there was some other utility that they couldn't put the plans, the sprinkler heads on the plan in that particular location. Maybe they needed to add piping.
But isn't that stuff kind of considered before you put out an order for doing a project?
Sometimes yes, and sometimes no. Sometimes there's just unforeseen things that come up. I'm talking as a civil engineer. But Ms. Zimmerman would be able to, supply a little bit more explanation as to why they made the changes they made. That's about all I can tell you in terms of what they did.
So why does Ms. Zimmerman have the knowledge to request a change?
Well, she's working directly with the contractor and their consultant. So both the design engineer, or the architects in this case, and Rash Construction, who's actually the prime contractor on the project. So they would have more direct knowledge. I'm not down there on a daily basis. I'm never down there. But I would hope, I would trust that that these changes were needed, and certainly the plans and specifications and what have you were done in a fiscally responsible manner. So I don't have any reason to doubt that they were. So, but there's a lot of things that come up. Our engineers do plan sets all the time. There's unforeseen things that happen. There's some changes that need to be made. That becomes a change order. And I suspect that's what happened in this case.
Commissioner
If I may, just in general, change orders, they don't really represent nefarious activity by contractors, designers, staff, massive oversight. In general, change orders usually are represented by just a few things. One is unforeseen conditions. You get into a project, you had plans and specs, and lo and behold, something isn't as it appears, and that happens. It happens on vertical construction. It happens on horizontal construction. Another reason for a change order is simply to add quantity. Remember, we as engineers, architects are doing bidders proposals, are raking off quantities based on the plan sets to establish unit prices that contractors put in their bidders proposal to establish a low bid. So quantities are not always exact, and rarely are. You're trying to estimate, tens of thousands of yards of gravel, or thousands of feet of pipe, or cubic yards of concrete. When you actually measure those out, we need to make sure we change the contract to represent the payment. That's a change order. And another change order a lot of times is to add time to a contract if it's a time sensitive project, so the contractor doesn't get penalized. On the flip side, if they decide to drag their feet, then you can impose liquidated damages. A change order will also reduce that cost of that contract, and sometimes quantities get reduced. So, I think the change orders that come up, at least the ones that we handle in public works and engineering, we're pretty judicious about what we're looking at. I'm sure, as Ron said, Director Zimmerman's working with their designers, their architects, their engineers, their contractors that are making decisions that, I mean, is it a change order to turn a porcelain toilet into a gold toilet? No. But it's probably something that is needed, something they came across in the project, I would assume. And then you have the option to defer the item and bring it back to the next committee if you'd like a better explanation from the director or who's working for it directly, but we were asked to speak on it. That's what we have to offer at this time, unfortunately.
Yeah, no, I understand, Mr. Maria. I've been here long enough to have heard that explanation a couple of times, and it always seems unique to me that things come up that are unforeseen. Like, they didn't know at the beginning, like number 9, change door from oak to birch, expedite shipping. Oh, what's the difference between an oak door and a birch door? I mean, I don't know.
It's a legitimate, fair question, and I wouldn't, unfortunately, either Ron or I can answer that. You know, if there's a rhyme or reason for that, I'm sure the director could answer that specifically.
It might be as simple as availability.
Yeah, you know, could it be that they supply chain issues and they're changing, you know, a different material? Again, we don't have all that nuanced information about it. It's a legitimate question, but we're just
Alder Perez,
passing it through.
excuse me.
I'm sorry, Karen.
No, you're fine. I cut in. My apology. I was just gonna say, would it help if we were to ask Ms. Zimmer to give us an explanation before council meeting next week?
Yeah, I don't think so, but I mean, I look at stuff like this and think, well, didn't they find this ahead of time? But I think Mr. Molitor's explanation that maybe the door wasn't available, they had to do something else. That makes sense. That part makes sense to me. But when you already come up with a plan and you go, oh, you change the door from a certain oak to birch. I don't know what the difference between oak and birch is, you know? So is it solid core? You know what? For that price, it better be, you know?
And it may be that exactly, and it may be that it was gonna be another 6 months before they could get that open.
Yeah, no, right.
So-
That made total sense.
Yeah.
to me. Yeah.
Alder Rouse and then Alder Pete.
Just quick, this is funded by the library right now, city of Racine.
That's correct.
Correct.
Alder Pete.
Yes, I'm trying to figure out what the total price is with the additional figures, cause I'm looking at the number, don't add up. to one.
So there's those numbers, so you have 10,005, so if you look at the decrease in the contract is 10,500, right?
I think it's 600.
I'm sorry, 10,600. And then, so then,
I've been doing this all
so that's total up in that column. The total increased contract amount is $15,997.64. So the difference between the 15,097 and the 10,500 becomes a net addition to the contract of $4,497.
All right, well, what's the total contract?
The total contract up on the upper right says original contract, $1,783,280.
Okay.
We have no previous change orders. This is the first one. And so that original contract plus that 4,497 comes up to your new total of 1,787,777.8.
Okay, thank you. Yep.
Any further questions? If not, a motion is in order. Second. Motion and second to approve item 0558-22. Any no further questions, comments? All those in favor, please say aye.
Aye.
Opposed? Motion passes. The next item is 0570-22. Communication sponsored by the chair on behalf of Tom Mobeck, Department of Parks and Recreation, submitting change order number 1, the contract 202-1093, Zoo Path Emergency Repair, BK Contractors, Inc. Contractors. Staff recommend change order be approved in the amount of $19,276.14. And Mr. Mobeck, I apologize. I was gonna get all those out of the way and then go back, but I forgot, so.
That's okay. No problem. There's only one. Yeah, this project, if you have walked the Michigan Pathway, this is right behind the zoo area that was compromised by the 2020 storms. And for the longest time, we had it kind of temporarily fenced off. This project that was completed earlier this spring was done by BK contractors. And what happened was the riprap, the amount of riprap that needed to complete it, according to the contract, it needed to be more to make it happen. The big rocks that are there. What's nice about this, even though it was a change order, it made it a little more expensive. The riprap that's there now with the new permanent project that will go in there, hopefully will be coming to you guys this year yet. That can be reused. So it's not like it was spent, it can be reused. So I'm looking for you guys to approve this change order dollar amount.
All the rest.
What is the proposed failure date of this? Do they give a 20-year average of lasting or anything like that?
I don't know if anybody can predict that, but I don't know. I would have to find that out. So, with the lowering and raising of water levels, I think that has a play with it. I do know that Smith Group that is doing the work on that is doing some type of a study on that. So they might be able to give us an answer, possibly, but I would have to ask them.
I'm just thinking along the lines of a guarantee, if it fails this year because we get a storm that wipes it out again, and do we have to pay again or do they cover it?
I would say, I don't know. I can't answer that one. I would say a warranty on that would be almost impossible. I don't know.
I think they're doing some resiliency planning and a lot of the stuff they're looking at for the various shoreline restoration, whether it's a pathway or Pershing. So, they're looking, and they've shown us some things that they've dove into about historic water levels, historic type of storms, about what direction they come from, wind speed, type of waves. So they're taking that all into consideration with the rise and the fall of Lake Michigan. I think they're creating designs that minimize that exposure. I think it's almost impossible for them to predict a storm that may happen that you don't design for. So,
But
they are looking
the
into
idea is to design and then perform the construction on something that is meant to last as opposed to just be temporary.
Okay.
So,
Thank you.
Any further questions from committee members? If not, I will entertain a motion.
Move to approve.
Okay.
Motion and second to approve item 0570-22. All those in favor, please say aye.
Aye.
Any opposed? Our next item is 0569-22. Communication sponsored by Alder Jones on behalf of Tom Bobak, Department of Parks and Recreation, to submit final payment for contract 202-1093 Blue Path Emergency Repair, BK Contractors, Inc. Contractors. Staff recommendations that the work completed by BK Contractors, Inc. on contract 202-1093 be accepted and final payment authorized for a total contract amount of $78,676.14. Final payment to include retainage. Fiscal note, contract 202-1093 was authorized under resolution 90945-21 dated December 7th, 2021. Mr. Molback.
along with the approval of the change order, we're looking for that to be added to the original contract dollar amount and looking for final payment approved.
Did you have anything to add, Mr. Pershaw?
I have nothing to add.
Thank you. Alder Perez.
So you're telling us that even though we just approved the change order, the work has already been done and completed, and so you want a final payment now? So work was done without approval? But a yes
At this
or no,
point,
sir?
yes.
I know a lot of times things are time sensitive and we wouldn't not approve it. I get that. But I've asked this in the past, there's going to be a change order and we can bring it in before they actually do the work, so we can anticipate what is going on with that. I think that would be a good process to follow, sir.
I have no problem with that. This year is the first year that our department does not have an actual person doing these type of work. And I'm learning as I go. And Ron, and I have no problem with making that work. I have no problem with making that work.
So what you're saying is you have no problem and blame your.
No, I'm not blaming you for anything. That is very helpful.
And just for clarification, we as professionals, we issue field change orders all the time. It is not plausible, realistic, or even economically efficient for us to tell a contractor, stop. We have to get this through to a committee and go to town council, get it approved. So a lot of the stuff that is done, if it's a complete change of scope that we really believe is in your best interest to approve that, but if it's to keep the job moving and there is budget to do it, we're gonna keep the product. Otherwise, the contractor leaves the site, they're gonna have to pay for remobilization and all those costs. So we do issue field change orders and bring them through as we go. That is a matter of course, in this business. I've been practicing like that in my 32 years as an engineer. So,
John, I appreciate that statement. That helps.
Alder Perez,
So, I'm wondering from a legal perspective, and maybe Mr. Letney can tell us that. Is it legal then for you to do something that we don't approve or have not approved? I know the exigency of the need is there, and we've done that in the past. But we've always been told that we're the ones that have to approve things going forward. And so I don't think, giving you the authority to make change orders at the moment, although I see the need for it, is actually permissible with the way it's written for us to approve changes in money. And maybe Mr. Lenny can address that.
Well, there's a couple of ways to talk about it. One is, it depends on the scope. I mean, if you're talking about a couple $1,000s, department heads have some authority to approve things on their own. If it's a significant scope, you got $1 million contract and it's 15% over or something like that. I can see how you might like to see that first. Now, there are some legal theories. I don't want to talk about them as theories if they're not real. They are real. That if somebody performs work for you and you accept the benefit of that work, you are required to pay the value of that benefit that you accepted, even if you didn't authorize it ahead of time. Now, there's limitations to that, but this is one of those similar circumstances. I think a project's going, there's something that needs to get done. As John said, there's room in the budget for it. The council would have a difficult time. I mean, what you're doing is coming back and ratifying it after the fact, but the council would have a difficult time not ratifying where the city has accepted the benefit of whatever that work is. So, I mean, it is possible, and John and his team will know the effect of this, but it's possible for the committee and the council to say, when we say $1 million contract, we mean $1 million contract. Don't go over that unless you come back and ask ahead of time. Or maybe you give some authority to exceed by 5%. I'm just pulling something out here. And that's just assumed going in. That can be just a policy issue, or it could be explicit.
So I'm wondering if when and if we have training on what our responsibilities are as alders, that a policy can be created to inform us that there is a need, especially in public works, to make on-the-spot decisions that will affect the money that may have to come up at once with a change order and a final payment. So that we know and can anticipate, oh yeah, if this needed to be done, we know because of the theory that you've gotten the benefit of the use of it, that we have to pay it because it's already done. Okay.
That's really something we can talk about amongst us, come back.
Thank you.
Any further questions from committee members? If not, I will entertain a motion.
Move to approve.
A motion and second to approve. Item 0569-22. Seeing no further questions, comments, all those in favor, please say aye.
Aye.
Opposed? The motion passes. Thank you.
Thank you,
Mr. Mulder. Our next item is 0563-22, communication sponsored by the chair on behalf of the Department of Public Works to submit final payment. Contract 202-2029, Main Street Lift Gate Replacement, Drax Inc. Contractors. Staff recommendation that the work completed by Drax be accepted and final payment authorized for total contract $192,638. Final payment to include retainage. The contract was authorized on the resolution number 0101-22 dated March 1st, 2022. Mr. Critchloff.
Thank you, Madam Chair. The contract 202-2029 is complete. That's the Main Street Bridge liftgate replacement. And the contractor is requesting final payment. Final payment is $192,638.00. And again, authorized under resolution number 0101-22 of March 1st, 2022. The funding should come out of the org object that is listed in the memo. In addition, I'd like to add that the work that we do on Main Street Bridge, not only for this, but other projects, is 100% reimbursable by the state. So because these bridges, they're on state highways, there's a program, we get reimbursed for all of this.
That's great.
Get money back.
Definitely a benefit, yeah.
Any questions from committee members? If not, I will entertain a motion.
Move to approve.
Motion and second to approve item 563-22. Seeing no further questions, comments, all those in favor, please say aye.
Aye.
Opposed? The motion passes. Our next item is 0562-22, communication sponsored by the chair on behalf of the city engineer, amending chapter 94, article 3, parking regulations, specifically section 94-141, no parking zone, schedule F. Add the following items to section Provincials 23, Provincials closed, no parking from 6 a.m. to 6 p.m. on Mondays through Friday. Indiana Street East Side from 20th Street South 150 feet. Staff recommendation is to approve the amendment to the municipal codes. Physical note, nominal fees to produce and install the signs. Mr. Mulder.
Thank you, Madam Chair. This is just like last time where I'm just amending. This is basically to accommodate a business that is having difficulties backing trucks into their truck bays to load and unload materials that they're producing. And also to accommodate its industry on one side of the street and residential on the other side of the street. So also to accommodate the residential parking, overnight parking. We're trying to allow them to park in front of their houses and things like that at night. It's pretty simple. We talked to the resident that the only resident that's connected there, they're okay with this parking restriction during the day. And then the industry is happy with the fact that they can get their trucks in and out during, or I'm sorry, the residents are happy at night.
the industry is happy for being allowed to get in and out during the day. If the committee agrees, appropriate action, we'd approve the amendment to the municipal code as described.
Thank you. Questions from committee members? If not, a motion is in order.
Motion to approve.
Motion and second to approve item 0562-22. Seeing no further questions, all those in favor, please say aye.
Aye.
Opposed? Motion passes. Our next item is 0574-22. Communications sponsored by the chair on behalf of the city engineer requesting approval of the transportation project plat for project 2703-09-01 North Main Street project. Staff recommendation that the request be approved. Further, that the mayor, city clerk, and necessary city staff be authorized to execute the easement document as requested by the Wisconsin Department of Transportation. Physical note funding is available in the 2023 CIP budget. Mr. Molitor.
Thank you, Madam Chair. Like it was mentioned, we are submitting this right-of-way plat for North Main Street reconstruction project. Requesting approval of the transportation project plat and acquisition of the property in fee and temporary limited easements. This project limits are from Gould Street north to Melvin Avenue. The acquisition of property will be completed in the next 2 years. The right-of-way plat is attached for reference. The roadway reconstruction project is scheduled to begin in the spring of 2025 and completed that year. Basically, this is after signatures, this allows the legal department to start acquiring property from the property owners in order to complete this project. If the committee agrees, appropriate action would be to approve right-of-way plat and authorize signatures of said plat. And then acquisitions can commence.
Thank you, Mr. Molitor. Alder Perez.
Can you give me a simple explanation of what a plat is?
Right-of-way plat is the land that's required in addition to what's already exists. 99.9% of this is temporary limited easement version, where we're just basically grading beyond the sidewalk. The 0.1% is little slivers at the corners where we needed to acquire extra land because we have to redo all the handicap ramps to today's standards. And that's where all the fee acquisition is at the corners.
But this is all private property, so they have, we have to allow them to get on their properties. So, we have interest in it. So if you look at the plat, if you ever want to, there is a schedule of interest on it. And every one of these properties has a little number, and then it corresponds to the property and how much we're taking, like Tara said, if it's for temporary easement or in fee. And then what Scott's office does is they get appraisals on the value of that land. And there's a monetary transaction for us to use their property temporarily, put the grass back, but they're entitled to that. It's required by the DOT that goes with this.
Okay, thank you.
Any further questions from committee members? If not, motion is in order. Motion second to approve item 0574-22. No further questions, comments? All those in favor, please say aye.
Aye.
Opposed? Motion passes. Next item is 0571-22. Communication sponsored by the chair and Alder West on behalf of the Commissioner of Public Works, submitting the following alleys to be included in the 2023 public hearing for 2024 construction. Staff recommendations that the following alleys bound by 4th Street and North Memorial Drive and Liberty Street, 20th and 21st Street, and Center Street and Grand Avenue, as submitted by the Commissioner of Public Works, be considered for reconstruction with Portland's cement concrete paving for the 2024 construction season and the 2023 public hearing, and that a preliminary resolution be introduced. Principal note, this is an accessible alley project, and therefore all costs will be paid by the abutting property owners. Mr. Mullender.
Thank you, Madam Chair. As mentioned, this is a preliminary resolution for the paving of these two alleys. Basically, this is to notify that we are putting these two alleys up for public hearing next year and will be considered during that public hearing. If approved during that public hearing, it will be reconstructed in 2024. So this is a couple of years out for construction. This is, as also mentioned, this is an accessible alley project, and therefore all costs will be paid by the abutting property owners. If the committee agrees, appropriate action would be to approve the preliminary resolution to start the accessible process of public hearing for the alleys listed above.
Thank you. Excuse me, Mr. and Mrs. Rose,
Yes.
did you wish to speak on this item or you just wanted to observe? Okay, thank you.
Can I ask a question?
If the alley is accessible and accessed by city trash collection, because that's where they collect it from rather than Forest Street. Why is it private property responsibility financially? As opposed to at least being subsidized partially by the city, if the city vehicles are using it.
Mr. Moody? Well, the logic behind, the way these assessments, the benefit for the reconstruction of an alley is a benefit to the abutting property owners as opposed to the benefit of the motoring public. So, I mean, the fact that we do alley pickup, is what we do. The waste collection could be done curbside as well. But the alleys are 100% accessible to abutting property owners, and that's the way it stands in the city of Racine. Because they're the ones that are using this, where they drive down and accessing their garages. I understand that Public Works does pick up waste there, the Parks Department plows them, but they are considered different than street right of way in that regard. Because street right of way is a benefit to all motorists of the road, users of the road that go up and down. Now, there are streets that get up that are also brought up for public hearings and assessments, but those are governed by the rule of whether those streets were built out of the community pavement or not at the time that they were originally constructed. I think everybody has a committee familiar with that. However, alleys are just simply for the benefit.
Okay, well, one of the reasons I was asking that, even just a minor subsidy from the city, is because the trash collection up the alley, and I understand it's a benefit to the property owners, but that's causing wear and tear. And let me share with you, some of the craters in this particular alley would really be hard pressed for a normal wear and tear of even 25 years worth of travel just by the property owners who have been created to the level they've been created. Again, I'm not looking for a free ride. I'm just wondering why they couldn't at least be partially subsidized. That's all.
Alder Ross.
I know back and forth is normal, but I'd probably say that could be a good chance to petition your block, your neighborhood, to say, hey, these large vehicles, and especially if you're up for consideration for a new alley, great time to do it. Say, this is nice, but understand the detriment to our alleyway, this degrades faster because of it. Is it worth it? And if not, that might be something considering to reach out to your neighbors and say, hey, when we get this new alley, if that does happen, let's consider not having our garbage picked up down the alley, something along those lines, just to preserve that.
Thank you, I appreciate that.
Thank you, Alder Ross. Any further questions from committee members? Does that answer your question, Mrs. Russell? Thank you. I will entertain a motion. It's item 0571-2. Thank you. It's been motion and second to approve item 0571-22. Seeing no further questions, all those in favor, please say aye.
Aye.
Opposed? Motion passes. This concludes our agenda for this evening. Thanks, everyone, for participation and for your attendance. Enjoy your evening.
Thanks for going.
You're welcome.
I appreciate that. I've learned how that.
Tied up all night.